Good afternoon and welcome. My name is Banaz Mansouri. I'm a senior attorney with the Unemployment Law Project. For everyone celebrating Hanukkah, we wish you a happy Hanukkah, and we thank you for joining us today. The Unemployment Law Project has been around since 1984. We're the only freestanding legal aid organization in the country solely dedicated to unemployment. The Unemployment Law Project provides free legal advice and free counsel to claimants in Washington state who have been denied unemployment benefits or whose award of benefits has been challenged. We're here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to give you the latest news on unemployment law and benefits and to answer your questions. We'll answer your regularly asked questions in the presentation, and then you can also submit your Q&As in the chat box. We have enabled closed captioning for this webinar, and you can click the box on the bottom of your screen to enable that for yourselves. I'd like to introduce our speakers today from the Unemployment Law Project, Executive Director John Tierpak and Staff Attorney and Policy Director Ann Paxton. I will now turn it over to you, Ann.
Thank you, Banaz, and thank you everyone for attending our webinar. We have a lot of news this week, and especially a lot of last-minute news that I want to mention briefly before going into some of the big policy issues that have been taking shape. So, well, the first thing is that just this weekend, the state announced that it had authorized its safety review. The vaccine has cleared state review for Washington State. Vaccination will, according to the governor, begin as early as tomorrow. So that will have a significant impact, we hope, on all the unfortunate trends that have been happening over the last year. Basically, in terms of unemployment nationally, we've seen a very distinct trend about pretty much the highest levels in months. 1.3 million people applied for benefits last week. That was 853,000 for regular state UI and 428,000 for PUA. And that can be somewhat misleading only because there's some confusion about that data and when the states are reporting it. And also, as we've been seeing with the overpayment situation, a lot of data that's reported has to do with corrections to benefit programs that people are actually receiving money from, and they're not really new claims. However, there is a distinct trend towards real new claims as well. The 4-week moving average for total initial claims is now at its highest point since October. And we're also seeing a big rise in layoffs as well. Right now, we're at the 38th straight week where initial claims were greater than the worst week of the Great Recession, which happened in the 2007 to 2010 framework. A lot of workers have exhausted their regular state UI benefits. And as everyone knows from endless repetition by us, the December 26th is the date that nationally probably 13 million people are going to lose access to the federal CARES Act benefits, pandemic unemployment assistance, and the extension PEUC. That's a significant date, mostly because people are going to lose access to funds they've been relying on they've been scraping by on in many cases. And it's also important because it's the last day that you can apply for PUA. So we're expecting that following December 26th, any applications that are pending will still be resolved, either through the administrative process at ESD or through the through hearings at the Office of Administrative Hearings, if there's an appeal. In Washington State, claims are up 10.1% from last week. And it sounds like almost 25,000 Washingtonians applied for the first time for benefits. So what is this? I wanted to mention the status on the stimulus bill. It's called the stimulus bill because that would be normally its function, but in for more practical purposes, it's pretty much a support bill for people who are unemployed. Um, the economy is in a different position than it was in the Great Recession. The stimulus is not so much the issue as maintaining a minimum level of subsistence for a lot of people. So the important thing for this week is that December 11th had been the deadline for passing the spending bill that would keep the government open. And that was extended 1 week. So Friday is now the deadline for the spending bill. And that's important because it's right now, it's the only chance to get some kind of extension of the CARES Act passed. If that doesn't happen by Friday, at this point, unless there's a further extension, it will probably be a few months before we see a substantive extension. Right now, they're saying that if they reinstate and extend the pandemic unemployment provisions, it would create or save more than 5 million jobs. They released the jobs data last Friday, and they showed that 26 million workers were unemployed or otherwise out of work because of the virus. And as I mentioned, job growth has dropped dramatically. The interesting thing in Washington State is that the governor this week, and again, this has all happened in the last 5 or 6 days or less, the governor promised that some kind of extension at the state level of the PUA program will occur. And we don't have an exact number of days, but they're saying at least a month of benefits that is following the December 26th ending of the PUA and PEUC at the federal level. This announcement came out just as Governor Inslee announced the January 4th, the extension of all the restrictions in the state until January 4th. And also he announced a $50 million program of support for businesses in the state, which should also be of some help. That's through the grants from Working Washington. In terms of the job search requirement, that's also been suspended through January 19th, and the waiting week is suspended through January 21st. This week we were surprised and happy to see that the New York Times, which has been working on an article on overpayments for the last month or two, has released that article, and quoting Benaz as one of the experts on it. And this article, it explains that it's been pretty much a national situation involving this scandal, really, about overpayments, that the states have sent out a flood of notices to claimants who thought they were receiving benefits that they were legitimately owed. And many states are claiming that they're not owed, and they're collecting the bills. And one interesting thing from our standpoint is that the article is somewhat dated, because the stress is on the state collecting money and the kind of hardship that's going to cause to people. In Washington State, though, the problem has really been that people receive these overpayment notices, and in large numbers, possibly most cases, they weren't necessary. That's because what is happening is there was a federal crackdown on the accuracy of benefit payments coming out of the Right Benefit Program. And the states had to very strictly enforce the requirements. And they found out in many cases that people were receiving federal benefits, that is from PUA largely, when they shouldn't have been. They should have been receiving state UI payments. And that is one of the core requirements of the CARES Act, that you first have to be denied state benefits before you can even be considered for eligibility for federal benefits. So as a result, unfortunately, people received these notices saying you have an overpayment before it was clear to them that they had maybe missed a deadline to respond to some questions, or something else came up that prevented them from communicating correctly with ESD. And as a result, a lot of people were forced into panic, but it turns out that these involved pretty much, in many cases, switching the person's account from the federal program to the state program. So if you look on ESD's website under potential new claims, that was the label that was used to describe the program. You'll see that that it's indicated that in many cases, people will not have to pay back the money that they were notified in the context of we may garnish your paycheck, we may put a lien on your house, we may freeze your bank account, and we may hold onto your tax refund. So we've been trying to work on getting the word out about this. I wanted to just play again Lavina's TikTok PSA about overpayments, because I think it's got really important information. Although I have one correction that I will make in a minute. So this is just to give you a background on this, because this is extremely important. It's very significant, and it really has not been covered in depth yet. What people are still trying to grapple with this nationally and in the state with the idea of these overpayments. But the fact that there's an underlying scandal, there's a scandal beneath the scandal, that people were unnecessarily terrified by many of these notices, has not gotten the visibility that it should. But here's the basic explanation.
In October of this year, the Employment Security Department sent approximately 26,000 people this notice. According to ESD, these notices were generated because the federal government required the state to switch many people from federal pandemic unemployment assistance to this regular state unemployment program. However, by calling it a potential new claim alert, which is incredibly vague and not urgent sounding at all, only half of the 26,000 people who were sent this notice actually replied. Many people can avoid repayment or resume suspended benefits simply by starting a new claim with ESD. Not everyone affected can solve the problem so simply. That's because PUA benefits are larger than regular state unemployment benefits, so claimants could be responsible for paying back the difference between the two. If you didn't reply to this notice in time, you're probably receiving overpayment notices now, but you can still appeal. I'm working on a part 2 of this video that'll have general recommendations for people receiving overpayment notices. Reminder, this is for Washington.
Lavina had to include that reminder because she does have a national audience, and there's some of her TikToks will have a national application. But here is
in October of this year, the Employment Security Department sent approximately 26,000. If you received one.
Okay, that one is not working. What she explains in the next video is what you need to do in order to respond. If you get an overpayment notice, you can appeal. You should preserve your appeal rights by appealing within 30 days. In addition, you should, at the same time, it can be helpful in many cases to call the 1-800 number 800-318-6022. You may have to camp out by the telephone to get through, but in some cases, these overpayments can be ironed out because in many cases, they're not going to result in an overpayment. So it's a very big concern because the backlog of cases before the Office of Administrative Hearing judges is already quite large. And this is going to add a lot of cases that are really not necessary. So if there's any way you can solve it without going to the appeal stage, although you should not abandon the appeal, that would be very helpful to everyone. And I wanted to mention one other thing about overpayments. That is, there's a provision in the federal in the CARES Act which bars the states from granting a waiver for overpayments. And this is also a big issue because normally if there's under regular unemployment insurance, if there's a case of financial hardship, the wording is in equity and good conscience, the state may grant a waiver and the person would not have to pay back the overpayment, but that is banned under the PUA, which bans debt forgiveness. So luckily one of our state representatives, Jamie Bueller from South Olympia, she's a Republican, along with Stephanie Murphy, a Democrat from Florida, have introduced a bill that would shield unemployed workers from having to return their any federal pandemic unemployment assistance when the agency has made a mistake and paid them funds. So this, we don't know what is the what are the prospects for this bill to actually pass, but it's a good sign that there is some measure that's pending in Congress now that the bill's been introduced that would maybe bring some visibility to the need for this issue, to the need for this for the change in the law, and for the need for relief of people who've received these overpayment notices. So that's the wrap up for today.
Great, thank you, Anne. Okay, we have a claimant who has received an overpayment notice. They filed their appeal on November 28th. They have not received a reply in the mail yet regarding their hearing date. And their question is, how long does it take to receive notice of an appeal? And where can they find information regarding new claims, a potential new claim on the ESD site? So just quick, before I turn it over to you, Anne, I did drop some information about overpayments and the Benefits Payment Control Unit contact information in the chat box, as Anne mentioned. And I've also put a link to the potential new claims site link on the ESD website. And I'll leave it to you to answer questions about how long it takes to receive a hearing date after a claimant files an appeal.
Thanks, Benna. So I think this date is in flux. We have heard that there's still a couple of months delay to get an appeal that you file with ESD over to the Office of Administrative Hearings. And unfortunately, unlike under normal circumstances, they've been very fast about assigning a hearing date. But now there's a backlog of up to 3 months, we're hearing. What is the latest that you've heard, Benaz?
That's correct, Anne. It's about 3 to 3.5 months at this point. We do recommend that after you filed your appeal to call the Office of Administrative Hearing in a few weeks to see if you've received, if your file has been sent over and if you have a docket number. Once you receive your docket number, you can contact the Unemployment Law Project and we can do an intake so that when you receive your notice of hearing in a few months, we'll be ready to assign an attorney to represent you, because you'll receive the notice of hearing and your hearing date will probably be within a week to 10 days upon receiving the notice. So the sooner we can get you in to do an intake, once you have your docket, the better able we'll be able to source you an attorney ready for your hearing. Okay, great. We have a claimant who is self-employed and works part-time jobs. They had been receiving PUA in the spring and summer until August. In November, they were disqualified for PUA, saying they may be eligible for a new unemployment claim. They submitted the new claim and they were denied UI once again. They appealed the decision that disqualified them for PUA. In December, it was redetermined that had they filed for UI in March rather than April, they would have had enough hours to qualify for UI. All claims were then switched to UI. Then a few days later, they received a call that determined and disqualified them from UI because of the reason they quit their part-time job last September. Now they are stuck with a $14,000 overpayment balance. My gosh, this is tragic, and I'm terribly sorry that this claimant has to go through this. Is their original appeal still active if it has been redetermined? Should they appeal the redetermination, and can appeals be grouped together after submitting? They're trying to get their claim switched back to PUA in the meantime. I'm going to provide my ULP contact info to this claimant, but Anne, if you have some thoughts on his questions, that would be great.
Yeah, that sounds like a complex back situation that I'd really have to sit down and examine in detail. There's really a lot of confusion and a lot of people very concerned about whether they need to file a new PUA claim or restart their claim, and whether they have an active whether they have an active claim when they've actually been turned down for benefits. So we should really put together a fact sheet to get some guidance on this, although we're not all clear on exactly what is the status. But in many cases, you have to restart an existing claim. So, but I think we should look at your case on an individual basis to be sure.
You know, and one thing I would like to add just in general, because I know there are a number of people listening, when in doubt, request the hearing. You know, if there's you know, things that may be resolved prior to hearing, that's fine. You can withdraw the hearing request or show up to the hearing and tell the judge if it's resolved. But waiting and not appealing a decision can be problematic later, because then you would have to show good cause. And it's hard sometimes when you receive a notice and in plain English it says what the problem is and what the appeal rates are, to explain to a judge that, well, you were given this misinformation and you believed it would be resolved, and you can't remember the person you talked to at ESD who told you something was going to be resolved, and it's 6 months later, you finally get your hearing and the judge just doesn't buy it, so it's better to request a hearing and then see about other resolution points.
Great. Thank you, John. Sorry, I'm just gathering some information to drop in the link. We have a claimant who wants to know how they can get an attorney to assist them in recuperating $2,675 that was wrongfully taken out of their bank account when they have not received a single dollar from unemployment. I am going to drop the link for the Washington Employment Lawyers Association, if that might be helpful. But if John or Ann, you have additional guidance or resources, I'll turn to you.
If this is what is odd about this is we've had cases where, let's say, somebody had an overpayment assessed by ESD, they already began paying it back, or money was garnished. They win their hearing, and then the question is, when can ESD send them the money back? In most cases, we've seen ESD has been actually pretty prompt at returning money as a result of a hearing decision. But what I'm hearing here is that they just took the money, that there was no appealable document. If there was a document to appeal, again, read the notice, file the appeal. If it's late, if you didn't receive it originally, explain that you just found out about this now and did not receive the original notice. But otherwise, again, contacting Washington Employment Lawyers Association is good. It may involve some kind of civil lawsuit to get it back. But it sounds like a mystery why they would even take it out.
Great. Thank you, John. We have a question from a substitute teacher asking about, should substitutes file for benefits during the upcoming winter break, which starts in 2 weeks? They have not heard if there has been a final ruling made on substitutes and reasonable assurance. Is the situation still on a case-by-case basis? So should subs continue to apply for benefits, or are they not allowed to, since school would not normally be in session during the winter breaks? I'll ask that question first, and then there are a couple other parts to this question.
So my understanding is if the break is the same as the normal length break, then you would not be eligible for those benefits between terms. If it's longer, however, than the normal term, you should have some eligibility, but I don't know the details on that. So it may be worth a shot to apply for benefits if it's longer break than is normal.
And sort of a general thing, I mean, a person could always apply and answer the questions correctly. The problem we've seen with school employees applying during, winter break or spring break, is that they may have to pay back. And for some people, that's not a big deal. They see it just as a loan. On the other hand, for others, that can be a big hassle and very problematic. So if you're not eligible, it's better not to apply for that week, or answer the questions in a way that would not get you a benefit for that week, so you don't have to hassle with it later. And usually when I've had cases of people with overpayments from winter break or spring break, we almost always lose, in terms of the person having to pay it back. And it's pretty rare that a judge would rule that you would not have to pay it back. So in general, it's good not to apply when you are not qualified.
Great. The other two parts to the question were, they were asked to sub for the district if the school opens up in January. would that then, quote, qualify as having reasonable assurance? Their opening is, of course, dependent on the number of cases and guidance from various sources.
Very unique circumstance. I know with community college instructors, there's sometimes they talk about reasonable assurance and this issue of whether it's contingent on funding and class size and other issues like that. This is new for us. If you feel that that is not reasonable assurance, then apply for benefits in the week, knowing that it may be disputed later on. If you're intent on getting the benefits, it may be better to do that and risk an overpayment rather than not do it, find out later that you could have gotten benefits. And then if you try to go back, that seems like even more of a hassle. So if you can stand a possible overpayment, I know I cringe and most people cringe at the thought of giving unemployment security any money back, but it might be worth a risk, but it's an individual decision. Some people are more comfortable with a safe choice, even if they lose out on some money, but others wanted to take that risk. But it is hard when we have no history on this. This is the first year. Unemployment insurance did not exist during the 1918 pandemic, so we have no precedent for this.
Great advice, John, on applying now, since it's much harder to apply, almost impossible retroactively. The last part to this question is, if the district does return to in-person learning and benefits are hopefully extended, can the claimant still qualify for PEUC payments if the difference of what's made and subbing, or if there's a difference between what they're making subbing and what they would have earned under benefits?
So I'm assuming this would be from starting in December or January. So PEUC expires December 26th. So if you're talking about retroactive payments, you can get those for at least some period of time. But anything after December 26th, there's no more PEUC or PUA at this point.
Great. Thank you. We have a claimant who had submitted an earlier question. They have two active claims on ESD, the normal UI and the PUA claim. And the PUA claim is the only one that will let them restart a new claim. Not knowing if this will cause further problems or if they should be on the regular UI claim without talking to a claim specialist, they want to know if they should pay part of their overpayment before December 31st or wait until their appeal hearing.
Well, if you have an appeal, you should be able to get a stay on the overpayment notices while your appeal is pending. Unfortunately, at one point there was a number at Benefit Payments Control that you could call and talk to a person and get a stay. Unfortunately, that number now seems to forward people to, if I understood your email right, Benaz, now seems to forward people back to the general 800 number. So that means it's going to take a lot more time and energy to get that stay. However, it's worth getting. You would not be required to make a payment on the overpayment until your appeal is considered.
Correct. And I would say we've also provided an email address for the Benefits Payment Control Unit, and you can also send a message through your e-services account. And in every time you contact ESD, do let them know that you have in fact filed for your appeal. That is something that they wonder before they will grant a stay on the overpayment. And I also provided my contact information for the individual. And regarding the statement you made for the reasonable assurance for substitutes and the upcoming winter break, you had mentioned that if the break was longer than normal, and there's a request for some clarification on what you intended to mean by longer than normal.
Well, whatever the normal break time is, if it's 2 weeks and it's extended, instead becomes 4 weeks, that's really what I'm referring to.
Okay. And I understand that there is a lot unknown related to reasonable assurance and how it is applied to substitutes. Unfortunately, we don't have any concrete information. ESD has not provided any information. We are anticipating that these decisions will be made at the hearing level, and that will not occur until, the earliest to my knowledge is January or February. We will certainly keep probing ESD for some clarification on reasonable assurance for substitutes for the past summer and for the breaks during this academic year. And going forward, and as soon as we have any information, we will certainly share. There are no additional questions in the Q&A box at this time, so we'll wait a couple more minutes. If you have additional information, please feel free to drop your question in the box. Okay, here we go. We have someone who is a self-employed person who had applied for benefits in April. No money was issued, no denial was issued. There was no PUA application made available. The call to the governor's office resulted in a message from ESD on November 10th that escalated assistance was in progress. ESD then made an inquiry, which was answered, regarding alleged voluntary separation from a part-time job in 2019 that the claimant worked for 10 hours. ESD has not yet resolved the voluntary separation issue, and December 26th is coming up fast. What more can the claimant do to preserve their right to apply for PUA?
Yeah, this is really unfortunate. The PUA law specifies that your job separation, you should be able to apply for PUA and potentially receive it, regardless of what your job separation situation was. But there's been a lot of screw ups along the way in getting that applied correctly. So it's very. I would make every effort to use the 800 number and try to get through, even if it takes several days. That I think for this kind of situation is probably the best option. If you haven't written to your legislators, that's also another possibility. And I don't know what to say about the expiration of the PUA day when people are barred from applying for PUA because of their e-services. That's a real problem.
Okay. It would hurt to contact your state senator and state representatives. It's easy to find. There's a website for Washington State Legislature. You put in your address, and you can email and call all three, one senator and two representatives. That certainly could not hurt. But keep trying. Don't give up. And different times of day, we've heard different stories that people can get through at different times of day. So it might be worth trying calls multiple times per day.
Great, thank you. And I dropped in the chat box the District Finder website, so you can look at who your state representatives are.
Yes.
Okay, we have a participant who says they had left a message with ULP for help with representation on their appeal. How long will it take to hear back from someone?
Well, we're getting inundated with calls. If you mean help with the appeal, if you have a hearing, we're of course prioritizing calls back to people with a hearing. If it's a question about general advice, we are getting hundreds of calls a week, so it's hard to say when you would be called back. I would, if you have a hearing specifically, I would call again if that was not in your message. If there's a hearing specifically coming, if that was not in your message, I would advise you to call back or contact us individually through this webinar. But as if you could put our email in the chat, that would work well.
Great. I will drop our contact information in the chat, and I did provide the participant my work email address to have contact me directly, especially if they have a hearing date. And on that, to John's point, if you have your notice of hearing and you have a hearing date and you would like free legal representation, when you contact our office, please be sure and state the date of your hearing and that you would like representation. We do prioritize those calls given the immediacy and the need for representation. But if we don't know that you have a hearing date or that there is a need, we will just put you in the queue and get to you as soon as we can. So we want to make sure we provide you with timely representation. So please let us know that you have your hearing date. Question Ann says that after the expiration on 12/26, people are barred from applying for PUA. Is that correct?
That I can't guarantee that you're barred, but what we've been advising people is please get your application in, because the CARES program ends at the end of the year. So to be on the safe side, we would not advise waiting till January if you have any option.
Great. No other questions right now. I'll drop our contact info into the chat box.
Thing I would like to add, just we're at a very unusual time in terms of what the future of unemployment will be, with programs running out at the end of the year, the federal legislature not making decisions right now, a new president coming in, a new Congress coming in. So I would advise people to, just follow news very closely on the state and federal level. There's talk of the state possibly taking action, if there is no action on a federal level. So all of these things are open to question on what's going to happen. And when also too, if you have a particular interest in this, it would not be a waste of time to email or postal mail or call your state and federal representatives to tell them how important unemployment is and how important action is in the coming time period. It was very encouraging to hear Ann talk about that proposal for the bill on the federal level to eliminate certain kinds of overpayments. That's very encouraging. But it's important to follow these issues and be actively engaged, because no way would two members of Congress from different parties come together on a bill if they were not getting hundreds of calls and letters and emails about people in their districts having these problems. So your voices can be very powerful, and it's important now, because whether you're acting on your own behalf or on behalf of friends and family, it's important that we pick a stand for a better unemployment system, especially since things are so up in the air now politically and otherwise. So it's good to make your voice heard.
Yeah, I just want to second that. The state legislators have indicated there's a lot of room for reforms this year. It's been very hard to get them to talk about reforms for several years, in fact, since the early 2000s. But in large part because of the pandemic and the federal programs that have been introduced and are now threatened with extinction, there is a lot more receptivity in our state government, among the state legislators, to fixing good cause quits, to make them make availability of a good cause quit for people who have caregiving responsibilities, possibly working on overpayments and other issues. So they've indicated that they're open. We have several of them engaging actively in outlining reform efforts. And so when the session opens in January, they'll be receptive, and it's always a good idea, as John says, to keep them informed, let them know that you are interested and you want to see things change.
That's excellent advice. I would piggyback on that to say anyone who has been a beneficiary of PUA would strongly encourage you to contact your state representatives. That program has not existed before in our state system, and it would be amazing if we could have that become a permanent part of our unemployment system. Millions of people have benefited: part-time workers, gig workers, self-employed, people impacted by health issues or COVID-related reasons. But in general, I think that there's a large demographic that's never had access to unemployment insurance, and this pandemic has just shown that there is a need. So if you've benefited from that system, please let your legislators know to do every effort they can to make that permanent in our state system. We have one other question. We have a participant who's currently receiving PEUC. If the PUA is extended, would they be eligible for extended benefits or additional PUA? They're unsure as to what they can get if their money runs out.
So PEUC, well, we don't know if PEUC or PUA will be extended. What the situation is right now, if you're receiving PEUC that ends December 26th, you potentially could qualify for 13 weeks at this point of extended benefits if you're receiving regular benefits now. If you're receiving PUA, you won't qualify for extended benefits. But as I mentioned, the governor has indicated that people who are on PUA now will have some kind of state program for about a month, at least a month, after December 26th. So that is one good thing. It's kind of unusual. I've not heard about any other states doing this yet. So I have to say this is a very positive sign from the governor.
That is wonderful. There are no additional questions. We'll wait just one more minute to see if anyone has any last minute questions they'd like to add before we close for the week. Be sure and check the chat box. I've dropped several links. You can pull them up there, and hopefully those will be helpful. And you can reach out to the Unemployment Law Project at any time with any questions you may have after or before these webinars. Okay, I'm not seeing anything else come through. Again, we wish Happy Hanukkah to everyone celebrating the holiday. We hope you have a wonderful week. We'll look forward to seeing you back next week, which we will hopefully have some important information on extensions of PUA or any other additional changes as the year is winding down. So thank you for joining us today, and take care.
Thank you. Bye.